All rise. Please take your seats. Good morning.
Good morning.
Mr. Hardio. Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of the Eastern Caribbean Supreme Court, Dominica, CCJ Appeal number 3 of 2018, between Gloria Shillingford versus Angel Andrew, for judgment this morning. Can we have the appearances for the court, please? Thank you.
May it please you, Honorable Justices of Appeal, Jody Luke of Lennox Lawrence Chambers, appearing for the appellant in this matter. The appellant is present.
Yes, thank you. And for the respondent?
May it please you, my lords. Michael Bruni, appearing for the respondent. I apologize again for the absence of the respondent, who is normally resident in England and who may just be monitoring the decision online.
Okay, thank you, counsel. Justice Barrow will deliver the judgment.
May I just point out to your lordships that I can't quite see the video for the court, from the court, so that everything is frozen, so I will listen.
Well, that's the most important thing.
Obviously.
Yes.
We can see you.
Yeah, we see you clearly.
Thank you. No problem.
And counsel, just as a little prelude, you may wish to embrace the rather easier notion of addressing the judges of this court as your honors and not have to distinguish between your ladyship and your lordship, etc. So it's your honors, which is generically neutral.
Thank you, my lord, and I can now see you.
Much obliged, my lord.
Right. This appeal is against concurrent findings of fact by the trial judge, Mr. Justice Cottle, although it purports to be otherwise. Before dismissing the appeal against the determinative findings of fact, the Court of Appeal fully considered why the appeal could not succeed and specified why it had failed. On the appeal to this court, the appellant no longer sought to reverse the findings, but sought to bypass them. The respondent, Angel Andrews, succeeded in the High Court in his claims against his sister Gloria Shillingford, the appellant, that Gloria, having sold Angel's lands pursuant to a power of attorney, made unauthorized payments to herself, her daughter, and Hilary Shillingford, their cousin, with whom Gloria entered into an exclusive agreement and to whom she paid a commission. Gloria failed in her defense to these claims, but succeeded in her ancillary indemnity claim against Hilary to refund the commission. Hilary was not a party to this appeal to this court, nor was the daughter, but Gloria asserts by this appeal that she properly paid the commission to Hilary. The court examined the findings of fact in the High Court and noted that the trial judge had made clear and direct findings of fact adverse to Gloria in a number of areas. He rejected her testimony as to sums she alleged Angel owed to her and to others, that Angel knew of and authorized her agreement with Hilary, and payments of various sums to Hilary and others, and that Angel had ratified her actions and payments. The trial judge also found that the exclusive agreement was, his words, no more than a fiction concocted by Hillary and Gloria in an effort to withhold from Angel a substantial part of the proceeds of sale of his property. At the Court of Appeal, Gloria challenged those findings of fact, but her arguments were rejected. The Court of Appeal upheld the trial judge's findings and held that he had good reason for deciding as he did, and it was open to him to find as he did on the evidence. The CCJ observed that in the instant appeal, Gloria was no longer appealing against the findings of fact. Instead, she argued that the findings that Justice Scotland made found and Angel did not authorize her to do were things that Angel ratified, and this made them binding on Angel. We concluded that the Court of Appeal's findings that the appeal could not succeed on the facts must now be treated as irrefutable, as there has been no appeal against the findings of fact. The finding by the trial judge that the exclusive agreement was concocted and a fiction remain undisturbed, so the appeal can go nowhere on the merits. The court was of the view that the findings that there was, as a matter of fact, no genuine agency agreement between Gloria and Hillary, and that the physical document purporting to constitute such agreement was a fiction, meant that there could be no discussion of its validity, or whether Gloria had power to make it, or whether Angel should be bound by it. In any event, the court noted that it was only in exceptional cases that it would disturb concurrent findings of fact. Since there was no appeal against the determination that the agreement was pure fiction, there was no need to consider whether there were any exceptional circumstances raised on this appeal to disturb those findings. And so that completely disposes of the appeal on the merits. Next, the court considered Gloria's arguments on ratification, which had been addressed in the courts below. The trial judge had found that Angel had not agreed to Hillary's appointment to sell the land, nor did Angel have knowledge of the agreement, while the Court of Appeal held that there had been no evidence of ratification by Angel, express or by conduct. Similarly, we found that counsel for Gloria had not pointed to any evidence or factor that supported the argument for ratification, and accordingly, we dismiss it. We considered the issues of law which engaged the courts below, and we found that they had not arisen on this appeal, as there was no agreement from which such issues could arise in this appeal. The dominant issue of law in the courts below was that Gloria had no authority to engage Hillary and grant him the exclusive right to sell the lands for a period of 6 months. The courts, applying the maxim delegatus non potest delegare, a delegate cannot delegate, found that the power of attorney given to Gloria had given her no authority to make the exclusive agreement with Hillary. This court held that on the settled basis that Gloria did not in truth engage a sub-agent it would be entirely academic to discuss what the trial judge found was a fictional agreement. The court examined Gloria's leading ground of appeal at the hearing as presented, which was that the trial was a nullity because the judge had allowed the trial to proceed despite violations of procedural rules. The violations were that the witness statement for Angel had been delivered late and that the trial bundles had been delivered the night before the trial was to start. The court found that the trial transcripts showed that at the start of the trial, Angel's counsel had disclosed the violations and apologized for and gave reasons for filing the trial bundles late. Counsel for the defendants other than Gloria had been fully and successively heard on the matter, while Gloria's counsel had not uttered a single word of protest or even mild complaint. The court held that the trial judge had not carelessly or perversely acquiesced in or ignored breaches of the rules. While there had been no formal application and no expressed order for relief from sanctions, the judge had considered the violation or alleged violation as fully as if there had been an application. And so, his decision to allow the trial to proceed was no less a decision to grant relief than a formally drawn-up order. The court also found that Gloria had not objected to the alleged violations, but had manifestly acquiesced in the trial proceeding, and so could not rely on the cases that she cited to support the alleged violations. In the circumstances, the court held that Gloria had not suffered any prejudice or hardship, far less injustice, from the breaches of the rule. We therefore dismissed the appeal, affirmed the decisions of the courts below as between the parties to this appeal, and ordered that Gloria shall pay Angel basic costs. We also ordered that the stay of execution pending appeal granted by the Court of Appeal be removed.
Thank you, Justice Barrow. It is clear, I hope, that what Justice Barrow read was a summary of the judgment, and let me be clear that it is not intended to be any substitute for the reasons you will find in the judgment itself. And second point is that part of the panel deciding this case was, of course, the President, Justice Saunders. You don't see him present today, but he is part of the panel and also signed the judgment, just to be clear about that. Is there anything you would want to remark at this point?
No, Your Honor.
No, Your Honors.
Thank you very much. Okay, thank you very much. Then this concludes this case.
Court rise.
Your Honor.